Hi, everyone. Harry here to talk about an aspect of the same motion in limine that Jack Smith filed and we talked about yesterday that so far seems to have eluded others' notice and I think is pretty both interesting and important. So the thrust of that motion is to keep Trump from offering all these political partisan attacks and trying in 6 different ways to say this is all a ginned up by Joe Biden, no less, prosecution, and that whole line of argument, which he'll try to smuggle in however he can, is A, false, more importantly, irrelevant. That is, it has no bearing on the charges against him. Even if it were true, the question would be, did he do the deed as alleged? And it's also like prejudicial, would confuse the jury, etc. So mainly this is about stuff that we know from Trump's continuing to pound the drums on it, and the campaign trail is going to be what he will try to defend with if he's not cut off from doing so, and this tries to cut him off from doing so, and it ought to be effective. That is, in many January 6th cases where they've wanted to propound similarly fanciful and irrelevant scenarios, the courts in D.C., the colleagues of Tanya Chutkan, have shut it down. And if they shut it down in advance, that's why you bring a motion like this, so that, you get the signal straight. And then when a Trump lawyer tries to say, well, now what's the real reason or anything like that, there's just immediate objection sustained, etc. No doubt he'll try to prove some tricks to insinuate it if he can, but that's the notion. Okay. There's another, however, part of the motion that concerns evidence that is highly relevant, highly probative, will be a big part of the case, and that is Trump's state of mind. So they have a whole different section trying to constrain the way that Trump would prove, or, by prove, I just mean offer evidence for. The burden of proof always remains with the prosecution. But what he can do to try to plant doubts in the jury's mind about his state of mind, as he's done, in a dozen different ways, mutually inconsistent generally on the campaign trail. I said peaceably, or I never knew this, or it was all because of Pelosi anyway, etc. And these are ways of trying to get at something that if a jury believed, like he was being just all, innocent, he had no idea, he would rile people up, they really could acquit him. Okay. The reason why this is so interesting, the first reason is, how do you generally prove state of mind? If you think about it, how would somebody try to say, I had no idea it was a bank. My car was just outside there or whatever, by testifying. And so we hit, boom, a direct collision with, Littman axiom number 1, if you permit me to copyright it, which is Trump can't testify. If he were to testify, it would be a debacle. The prosecution would have their pick of his thousands and thousands of lies, and which they could introduce, not forever, but to use the best ones to show he's not credible, for starters. And then he would clearly expose himself to perjury charges, which I think they wouldn't hesitate to bring. So they'll play footsie on this all through the trial, and maybe he'll even suggest he's going to testify, and maybe this is the one time that the axiom will be violated. But I go with axiom number 1, he won't testify. And I think the parties are also, because there's a sophisticated kind of understanding between the lines of this section of the motion that he's not going to testify, and they're going to try to get to sneak in state of mind evidence in another kind of way. And now this is pretty interesting, but we take a little detour into the rules of evidence and how you would try to sneak this in. All right. So the first way he would try to sneak it in is there's a witness on the stand who's a Trump partisan, and they try to get him to say, now, did the president tell you anything about his state of mind or what he believed about whether the marauders would be peaceful or whatever? Objection. Anything that Trump said, if it's of the form that Trump told me X is very likely to be hearsay, and hearsay is inadmissible. Now, it's a really strange rule because the government could introduce it. It's actually defined not as hearsay if the government is introducing it against an adversary opponent, that being Trump. But if somebody tries to testify on Trump's behalf, Trump told me, fill in the blank, that's hearsay. And you want a motion in limine, so this is established in advance, so it can't just be sort of blurted out to the jury, something they would try to do anyway, but it would be shut down hard. All of this is going to be interesting because such a completely incorrigible party, but it's going to be the lawyers there who Chutkan will totally discipline if they violate her order. So that's going to be the first thing. Can't use hearsay. Okay. And that's relatively clear, so maybe they wouldn't try it too much, but they go further. What else could you do to say, I think, Trump had this state of mind? Well, a witness could say, it seemed to me that he really wasn't trying to do anything bad. All right, that's not hearsay. That's not Donald Trump told me X. It's just, look, I was there, I was watching, and it seemed, I thought that, body language or whatever, it just seemed to me that, he would have done this otherwise, or maybe part of the whole wrangle about what's happening in the Secret Service car when he tries to grab the wheel, whatever. Just people would be saying, it seemed to me thus and so. Now, and here, Smith addresses it and really meticulously kind of dissects it. Why would somebody be able to say, it seemed to me? Well, we have two basic kinds of witnesses. We have experts and non-experts. And experts can provide, let's start with non-experts. Non-experts, are there to tell us what they saw, heard, etc. That, to relate what came through their senses, not to give us their own opinions or personal impressions. Now, that's a sort of rule that is kind of a little hard to police and often is honored in the breach. And that's why Smith is trying to draw the line right here. He says, look, if it can only be based on personal knowledge, the testimony of a non-expert witness. So you can't form a basis for starters, if it's just something that Trump told you, that's a hearsay problem. But just generally, it's not, strictly speaking, a proper opinion and personal opinion for them to go on and say, here's what they thought, etc. We don't care what they thought. We care what they observed. And so Smith is saying, and again, this is really trying to insist on a fine distinction in advance of trial. They have to be limited to what they personally observed. It would be so easy to slip in a question after, what did you see? And so what was your impression? Objection, Your Honor. We talked about this in the motion in limine. You need to get the signal straight. Otherwise, it'll be blurted out in front of the jury, etc. So a non-expert witness, and it's a fine line. Perhaps Chutkan will even let Trump go over the line, but that's the argument. Personal observations only. So he was sweating, or he seemed to be all red in the face. Data that somebody could use a jury could use to figure out state of mind, but the witness is just there to give the observation and not to go the next step and give his or her opinion. Okay, pretty fine distinction. Now, the jury can go back and say, well, wait a second, when they're deliberating, That witness said that Trump, whatever, crossed his fingers when he said it. But they take the next step and say, here's what it must mean. Okay, those are non-expert witnesses. Then there are expert witnesses. Expert witnesses can offer opinions. That's what they're there to do. They use their expertise to offer their opinions. But it's got to be helpful opinions. It's got to be something that the jury can't do for itself. My opinion based on my expertise is that these two fingerprints are the same. You couldn't have a jury apply that same expertise. But my opinion based on the fact that he crossed his fingers or whatever is that he was being dishonest. That's something a jury can do for themselves. That's a issue of just sort of common sense and experience. So under the expert rule, if they want to offer expert opinion, they says Jack Smith shouldn't be able to do state of mind stuff because it's not helpful. Okay, so do you see what he's trying to do? He knows, point one, Trump can't testify. Point two, Trump's state of mind is huge. I mean, we all saw it in front of our own eyes what happened, and the only way anybody could ever see all that and think somehow Trump didn't obstruct justice and do the things he's charged with is some kind of crazy notion in his mind, which is the human mind, especially Trump's human mind, is a recesses of mystery, right? So Smith is really meticulously. Trump's not going to testify, but he's going to try to sneak it in. So he's covering the waterfront in advance. No hearsay. Nobody says Trump told me he wanted there to be peace. But also no non-expert opinion, because we just want the observations, just what they saw, heard, etc. And no expert opinion, because that wouldn't be helpful. And those really would be the different ways that they would try to smuggle in something about state of mind, which is going to be huge. That would be, what are his hopes for winning or having a juror have reasonable doubt? The biggest seems to be juror nullification. Seems to be, that people would decide, I don't care what the evidence said, this is just ginned up by the Democrats, etc. That's the other part of the motion, because that would be improper, a violation of a juror's oath. Not to say, it never happens and there's really not much you can do about it, but that would be the first. And then the second thing would be if they decide, I have a reasonable doubt about his state of mind. And this is the way they're really trying meticulously to cover it all in advance. And that's what you do in a motion for limine. In limine, you're at the threshold of the trial. That's something, by the way, to note already. If it weren't for this immunity thing, we'd already be looking for getting ready for trial. The previous schedule had February, when the jurors were beginning to get questionnaires and the like. So at the threshold, you get your signal straight so that people don't make mistakes, really costly ones, or don't pull fast ones, costly ones, in the heat of trial. Now, this trial is going to be, just as we've seen in the civil fraud trial in New York. Trump push again and again on an irrelevant point, that being the law clerk. He wants, it's the same sort of dynamic as with the gag order. Go ahead, judge, hold me in contempt, throw me in jail. I want you to do it. That's how I'm going to win the election and make this whole thing go away. Now, of course, he's going to be sitting down, and it's really going to come to his lawyers. He's the client. He tells them what to do. But if the judge rules in favor of Jack Smith, she'll set some very tight constraints on the lawyers. Of course, we saw at the civil fraud trial, they basically were going for a mistrial, and they could do the same here. A mistrial were to happen. Let's say they totally violate her orders and get them to a witness to say something flagrantly improper. Really, the remedy is a mistrial if the jury has heard some really inflammatory, irrelevant testimony. Mistrial, that would be music to Trump's ears, right? You start all over again, and now that's a huge delay. So trying to actually, there's all these pretrial motions have a two-part kind of challenge for the government and the judge. First, to win on the law. Second, to actually, enforce it against a defendant, a criminal defendant who has incentive to actually try to violate and and totally act contemptuously to the court. That's going to be a general dynamic on a few different things, including the trying to keep him from charging a political prosecution. But on this, really interesting, can he get in state of mind evidence without testifying? See axiom number 1. And this is Smith's attempt to seal off every little hole in the room and pack it like a vacuum before the evidence starts, so that the rules are set. Will Chutkan go for it in all ways? We'll see. Certainly the hearsay part, and she might well go for it in all ways. And then, how will it actually work in the heat of battle during trial days, and what will happen when they push against the rulings? That'll be a source of drama, unlike other criminal trials, when that comes to pass. Talk to you later. Thanks for tuning in. If you enjoyed this video and other Talking Feds content, please take a second to like and subscribe. Talk to you later.